to prosecute, I want to say that I chaired a task force 3 years down the line to look at offenses that were committed subsequent to the post-election violence. The task force concluded a report that was presented to His Excellency the President, and after it was presented to the President, it was then presented to different arms of government to deal with the recommendations. But as far as prosecution is concerned, I chaired that task force as a prosecutor also, and I was expected to look at the evidence with the lens of a prosecutor, which requires me to be sure that before I can recommend prosecution, I have sufficient evidence and it is in the public interest, and I have a reasonable prospect of conviction. I used the law as it was, and I applied it to the circumstances, and I did my contribution to the task force, and whatever was presented to His Excellency the President was the result of the conclusion of the task force. That task force included civil society. Thank you. About bills going to Parliament and the government losing or courts declaring bills or legislation unconstitutional. First and foremost, it is the work of the courts to do that. That is one of the duties that they've been given. And if they do it, they are not doing a wrong thing. We should ask ourselves, why then the notoriety? I believe that most legislations that we have come up with of late have been to comply or to operationalize the 2010 constitutions. Most of the contents of those bills contain new jurisprudence, not only to the executive, but even to the judiciary. I take it as a testing time. We are testing the Constitution through bills, through legislation. Honorable Speaker and honorable members, a testament to this is that even in the Court of Appeal, there are issues that they've not agreed on, they have not given direction. It is a good thing for us to test a new legislation. It will be volatile for some time, but after some times when we have matured with the 2010 Constitution, then the law will be settled. But that having been said, it is a concern if bills are declared unconstitutional when the Honorable Attorney General has contributed to them. What I would do is to find out why they have been declared unconstitutional. Number two, I would make sure that as the Attorney General, I advise that wherever we come up with a bill, it meets the constitutional requirements as provided. Thank you.
Now, Dorcas nominee will take a batch of 333, starting with Isula, Posing, then on Gikaria, in that order.
All right, thank you.
One question each. No preambles.
Okay, please allow me to ask two. Chairman, no preamble. You have served in the AG's office before. Are there instances where the AG then advised the executive and the advice was not taken? What will you do if this committee finds you suitable in the National Assembly and you advise the executive on different matters and your advice is not taken? The second question is that there are areas or there are circumstances where cases have been lost in court, as you have said, but then the judiciary then orders compensation to the litigants. My question is, why should taxpayers carry the burden of the compensation while there is an officer in the executive whose decisions have occasioned the judiciary asking that that money should be compensated? And we have many litigants who've never been compensated that the judiciary asked that they get compensated. And lastly, the 2/3 gender rule. How will you make sure it is realized We cannot selectively follow the Constitution on the matters that suit us, but on matters 2/3 we don't. I will not speak again later, so there's someone who has asked a question from the public, that in Kenya today, the holder of a law degree is not eligible for admission to the role of advocates unless they attend the advocates training program and pass their bar exams. Currently, ATP is only offered at the Kenya School of Law. And so there have been attempts to review the law that mandates this. And so there is and the attempts have been received with different divergent legal view. What is your position on this?
Thank you, Chairman. Mine to the nominee, the Office of Attorney General, is practical one, which is, nominee, I want to know, or the people of Kenya, in assessing your suitability, we want to know, what is your opinion or vision on these contracts or clauses in contracts that a government entity enters with international companies. And in those clauses, the clauses inside those contracts, and I've seen it from being chairman PIC, where Kenya lose money, they put a clause to say that if there's a conflict in that contract, that the arbitration or the legal resolution will be done, for example, in London. And yet, Madam Nominee, through the chairman, the money is paid is 100% ex-checker, which means it's our money. And our case in point is GDC, where Kenya lost hundreds of millions of money in London through something I call kangaroo court called arbitration, where people can agree to fleece people's money and agree. Arbitrations
are legitimate courts within both our system and the international systems. They cannot be called kangaroo courts. That's not a fair comment.
I thank you, Honorable Speaker, but that's my opinion. Maybe it's different from the legal practice, but I found it a kangaroo court, Honorable Speaker, that just people sit down and agree. And Kenyans, Madam Nominee, through my speaker, has lost a lot of money through that process. So what's your opinion? Can we change the law and have a contract, particularly where Kenyan money, which is ex-checker, maybe if it's a loan, that's a different way. What is your opinion on that, Madam Nominee, so that Kenyans don't lose money as we lost through GDC? I thank you, Speaker, in that kangaroo court.
Not being a lawyer yourself, we forgive you. Go on, Gikaria.
Thank you, Chairman. Chairman, I have this question.
Yes, Junet.
Speaker, I thought Honorable Koseng is a lawyer. I saw him that time when we had the cases in Hague. I saw him carrying a lot of documents and saying that he's filing cases in Hague, and
that is exactly what he was doing, carrying documents. That doesn't make you a lawyer. Go on, Dorcas.
Point of order, Speaker. But
go on, sorry, Gikaria.
Chair, there is this review of the Constitution. There is a call for us to review the Constitution, either be it through the parliamentary initiative or the popular initiative, on some quarters, like not having even the opposition leader in parliament and things like that. And also the very thin line between, like what happened just recently, on a constitutional issue under Article 37 and the Public Order Act. Maybe in your view, Madam Nominee, what, in your view, are the sections that we need to look for in terms of the constitutional amendment, particularly to be able to align some of those very thin lines between Article 37 and the Public Order Act, where you have to balance the two for us to realize? So maybe in your view, which areas do we need to look for the amendment in the Constitution? Thank you.
Yes, nominee, can you deal?
Chairman, and my colleagues, my apologies. It has something to do with what I had asked. I just want to know the past costly AG advices to government, mainly driven by vested in-house manipulative cartels, especially in Treasury, and official systems operatives in huge government development projects. I'd like to know your view on that.
You can respond to those three honorable members.
Thank you, Honorable Speaker, sir.
But also don't call arbitrations kangaroo, because they are not.
Thank you, Honorable Speaker, sir, and members of this committee. I am not privy to any advice of an Attorney General under whom I served that was not taken by the executive. As to what I would do if my advice is not taken, I take it that the Constitution provides that the Attorney General is the principal legal advisor to government in legal matters. I look at the President as a vision bearer of the whole country. As he receives advice from the Office of the Attorney General, he has to take into account other sectors, because the law does not exist in a vacuum. He has to take into account socio-economic matters, security matters, and I believe he not only gets advice from the Attorney General, but also from those other sectors. It is the culmination of all these advices from different sectors in which I have no expertise to give that the President of the Republic of Kenya would make a decision. If the President of the Republic of Kenya is the vision bearer and everybody under him is working towards achieving the vision of the government of the day, I do not see where there can be a conflict. Otherwise, for me, I would give efficient, professional advice, which is just, which is fair, which is objective, which is truthful, and which is in accordance with the Constitution. The lost cases in the judiciary, I think it is important for me to say that I am not able to comment on why specific cases are lost unless I am seized with the information. But I also think that it is the responsibility of the Attorney General to put in place mechanisms to mitigate loss. And where loss is occasioned deliberately by an officer, to take action or to recommend action. The 2/3 gender rule. The Constitution provides that in all appointive and elective posts, one gender should not be more than 1/3, 2/3. I think this is an issue that has been litigated. This is an issue that is before this House. And I would be cautious in commenting on it unless I see what is before Parliament and what is in the Office of the Attorney General and the initiative. But I know that in the Office of the Attorney General, in the Office of the Director of Public Prosecutions, we have reached the threshold. Legal education and CLE. This is a rowdy place. Very, very rowdy. Very rowdy. And I say that because I live with some of those people. I have seen them. I empathize and sympathize with them. I understand that there are 2 task forces that are given reports to the Attorney General. Those reports are in the Office of the Attorney General. And pursuant to those reports, there are 2 bills pending before Parliament to harmonize legal education, to set standards, accreditation. Because, Mr. Speaker, sir, I am told that in some instances, you go to an accredited university, but when you go to the School of Law, you are not allowed or you are not admitted. I know these people are frustrated, and that is my priority, to go and look at these 2 reports, to look at what is pending in Parliament, and to make sure that we recall it back, because this was 3-4 years ago. There could be some intervening factors to make sure that we are responsive, because these people need a closure and they need to know. They legitimately expected that after learning law, they would be admitted. So I do agree This is a very rowdy area. It is frustrating, and it calls for priority, and it will be one of my priorities if I'm accorded an opportunity to serve. At the Office of the Director of Public Prosecutions, having found that this was a problem, we created a cadre called legal interns. We tried to bring in people who had gone through the School of Law, but for one reason or another could not be admitted because they were frustrated. In fact, we started by getting in 100 and we distributed them. But apparently that was not in accordance with what Treasury expected, so we had no money, so we stopped it. I also think that it is the responsibility of the Attorney General to relook at pupillage so that we can structure some pupillage mechanism within the executive so that we can absorb some of these children. It is an area that, as an Attorney General, as an advocate, and having been the Secretary of Public Prosecutions, I admit it is an area that needs urgent call. Thank you. I was asked about the vision, the vision of the office. Mr. Speaker, and honorable members, under the Constitution of Kenya, the Attorney General is the principal advisor to the government, also represents the government in court. At the same time, the Attorney General is supposed to act in public interest. It occurs to me that the Attorney General is wearing two hats. He is a lawyer, he is also a minister. But this public-facing, public interest part has not been very clear. Therefore, I vision to be an Attorney General who will actualize the vision of an Attorney General under the Constitution. Be a principal legal advisor to the government, represent the government efficiently and adequately, and at the same time, protect public interest, uphold rule of law, protect human rights, good governance and accountability. I will be a responsive Attorney General and a lawyer of the people. And I hope the Office of the Attorney General will work with all the peoples of Kenya in realizing our aspirations under the Constitution. When it comes to contracts which are eschewed, Honorable Speaker, sir, I don't have any information on this, but if confirmed, I would make sure that we come up with some SOPs, standard operating procedures. We set standards, and we make sure that the Attorney General is actually represented and reliably represented in the contracts from the beginning to the end. Because unless you look at the quality of the contract and you mitigate any loss or any risk, it is very difficult to succeed in the end. So there is a need for an Attorney General to be represented from the beginning, to look at the clauses to make sure that they're responsive to what we need and that they protect us. At the same time, should we feel that some of the clauses will be injurious to us, we could review. That calls for expertise and very professional state counsel. The third question was on constitutional review. Mr. Speaker, sir, and members, the Constitution is a live document. And within the Constitution itself, there are provisions for review, which means that there is room to review and amend the Constitution. However, the rule of law requires that all laws of Kenya are made by the participation or with the participation of the people. They must be clear, they must be available, and they must be able to be legislated. For that reason, it is only the people of Kenya who can say what they want to change in a constitution, because they have to be part and parcel of the law. The Office of the Attorney General can just be facilitative. Having had our constitution for the last 15 years, I would agree with those who are saying we are now ripe to relook at the Constitution